Okay. We can start and try to have you share that document.
Okay, can you hear me now, sir?
Yeah, and
Okay, it's fine. All right.
yeah, masichonge light into me so that yung into yakho ibe sorted. Yeah, unmute. Masiqhubayo unmute.
Okay.
Yeah, I think you're right.
Video,
Yeah, but ungayivala blind ivalisise because
don't get
no uyavela
blind. Oh, all right.
no uyavela kawushare.
Give me some few minutes.
Yeah, technology.
Hey, indeed.
That's why I did my scaling.
Yeah.
Technology yakwazi ngeli xesha kufuneka isebenze ngalo decide uyeka yona. Yabo.
And iyaphenikisa ngoku lawe.
Yeah, that is why ndithe masijule senze kakuhle siyigqibe then uyisuse then when you are called ibe ngona ke ngoku yabo to make our lives easy.
All right. I'm just closing up ezinye into ezandiphazamisa nje.
No problem. Let me piece.
Okay, so you want me to share the screen, eh?
Yeah.
Are you able to see the screen now?
Okay. I-double click i-presentation le. Awuqala apha uthi share. Ugqiba double click kule
Okay.
presentation ufuna uyisharishe.
Oh, okay. All right.
Qala apha ezantsi uthi share. And then izawuvela ii-screens ezininzi then you double click kwesaa screen ufuna sivele.
Hey, it's not even giving me that option. Can you believe it?
Okay. Uyambona ushare apha ezantsi?
Yeah, ndiyambona ushare screen.
Yeah, double click then kuzawuphopha up esinye screen esine-screens ezincane.
Okay.
Nantso ke. Uyabona ngoku uya kwi-presentation ke ngoku uklikhe ii-emails zakho.
All right. Iyavela i-presentation.
No, you are on your emails ngoku. Vala ii-emails zakho uye and go to the presentation.
Oh, I see. Okay, let me close everything.
There we go.
Okay.
Jonga
All
ke,
right.
go to your bottom right. Uyabona apha ezantsi?
Lap.
Yeah, sure, slideshow. click landa buya bu right landa ithi slideshow.
Okay.
Double click.
Okay. Maybe up.
Up.
Yeah.
Yes. Yeah.
Okay.
Double
Yavela.
click okay.
Are you able to see it now?
No, ngiyayibona presentation, but I want it to be on presentation mode. Go, it's on.
Oh. Okay.
That's why I'm sitting here. Yes.
All hlobo ne?
Yazibona funeka zivele ezi slides lapha left kuthi so that izobonakala kakuhle. Wena ngoku double click again kula nto bendikubonisa yona. Yes. Double click
Okay.
to your right.
Up.
Yes. Double click laa nto izawul pop up as one.
Is it still not showing?
Ivele as what kuwe.
As a first full page introduction.
Azivelanga ezi slides lapha left. Okay, phum. Okay. Okay. Kawuphuma uphinde uqalele. Iyathanda uyenza sometimes.
Kunanzika ndi-stop ushare.
Yeah.
Okay. So siqalele ekuqaleni.
Awuyenza ungayisherishanga iyalanduka iyakwazi uphopha.
Inanzika i-presentation.
Yeah.
Yeah, iyavela ngoku. In fact, it always comes ngolu hlobo in presentation form. Wena awukwazi uyenze ulokhu iqala and then ushare screen.
Okay, sharp. John, I said,
Yeah,
let me see it. I want to show you this thing.
All right. Okay.
Yeah. Uyayibona le presentation. Yabona up on my left.
Yeah.
Yeah, it must not show these things. Yes.
Oh.
So
okay.
how you do it, you go here. I'll just close this. So wait. Was man?
I don't see your cursor.
Okay, I've stopped sharing. Stop share. Okay, share. Double click, and then up right. Yabona up.
Yeah.
Yeah. When I click this, it does this. Then you can go
Oh.
next.
Let me just give it a try.
Yeah, uyayibona? It must be like this. So you double click there. Ilula nje kanjalo. You share, you open the presentation,
Okay.
and you just double click there. It's out. Papa.
Oh, all right. Okay.
Kawenza. Sure. Otherwise, it's not it. Yeah, winning.
Hey.
Yapa.
Yeah, I've just clicked now.
You double click up, man. Three click a guy one. It's the ends.
I've clicked it twice.
Yeah.
Yeah. You see, this is where I am right now. Can you see the curse on your side?
I just need to.
Recording in progress.
Good morning, colleagues. I think we now reach a quorum. Sia will come in on the quorum issue. See, are all members here? I see Ms. James, Honorable Jonas, Engel, Mrs. Ngaba, Honorable Muela, Honorable Sokopo, Babgasa, Honorable Moali. Okay, I think we have the majority of an Honorable Claude. Then we can start. Sia, do we have any apologies?
I'm not sure. We don't have an apology from members, Chair. The only apology we received was from the Minister's office, the Minister. But today it's not, we didn't invite DCS, Chair, so it's our committee meeting. Thanks, Chair.
Thank you, Sia. Good morning, honorable members on the platform, members, and those who would have joined the meeting. Today's meeting is the Portfolio Committee meeting. I think I've seen DM. Good morning, DM. It's the Portfolio Committee meeting where the committee will get a legal opinion from the Parliamentary Legal Services on the PP report that has been circulating, and also that the committee would have received through the Speaker's office, for us to be able to do our oversight work and have solicit a view from the Portfolio Committee on an approach on how to go about the Public Protector's report. So I wanted to make it clear because I see we have DCS in the platform. Kindly note it's the Portfolio Committee meeting. We didn't invite DCS for this meeting today. DCS will then be informed once the Portfolio Committee has taken a decision on this matter on how to navigate or to move about it. So you are at liberty to join in, you are at liberty to equally leave in the platform. Those who have joined from DCS. See, I flag the agenda so that then we can start. Members, this is the proposed agenda for today's meeting. Can I get any mover or seconder to the proposed agenda?
I will move, Madam Chair.
Thanks, Honorable Engel.
I support, Honorable Chair.
Thank you, Honorable Moali. We'll then go straight to the briefing by the legal services, legal team of Parliament on giving the Portfolio Committee the legal opinion on the Public Protector's report. I would have received the Public Protector's report from the Speaker's office immediately after the PP would have issued the report out. For the committee, the first draft was for the committee to note whilst it was still on the drafting stages, and now we received a final Public Protector's report, and therefore this meeting was to then get a legal opinion from that Public Protector's report so that the Portfolio Committee would know what is it that we're required to do whilst we do our oversight work on the department. So Sia, I'm not sure who is coming in. Mediale, welcome.
Chair, it's Mr. Bulelani Simani from our Parliament Legal Office. I've asked him to even switch on his video when he comes, Chair. If through you, Chair. Thanks.
Okay. You can come in, Mr. Bulelani Simani, for you to be able to take members through.
Thank you, Honorable Chairperson. Good morning, Chairperson, and good morning to all the honorable members and the officials from the Department of Correctional Services. Thank you for the opportunity to present this opinion to the committee. Our office, that is the Constitutional and Legal Services Office, was requested to advise the Portfolio Committee on Correctional Services on how to process the report of the Public Protector on the investigation into allegations of improper conduct by the functionaries of the Department of Correctional Services relating to the escape of Thabo Bester from Mangaung Correctional Centre and allegations of undue delay and omissions by the former Deputy Minister of Correctional Services to intervene regarding the incident. This request for legal opinion is made in light of a pending litigation between the Department of Correctional Services and G4S, that is a security company subcontracted by Bloemfontein Correctional Contracts to run Mangaung Correctional Centre. Just a brief of a background that the Honorable Chairperson has touched on briefly. On the 18th of July 2024, the Office of the Public Protector issued a notice in terms of Section 7, subsection 9 of the Public Protector Act of 1994 to the Speaker of the National Assembly, affording the National Assembly an opportunity to make submissions in relation to the envisaged remedial action. Just for the purpose of clarification, Section 7, subsection 9 of the Public Protector Act provides that if it appears to the Public Protector during the course of an investigation that any person is being implicated in the matter being investigated, and that such implication may be to the detriment of that person or that adverse finding pertaining to that person may result, the Public Protector shall afford such person an opportunity to respond in connection therewith in any manner that may be expedient under the circumstances. That was the purpose of that notice that was issued in July. The Speaker referred the notice to the committee to note or comment alternatively, if necessary, to make submissions in relation to the Public Protector's intended findings and remedial action. Accordingly, the committee responded within the prescribed period, noted the notice, and stated that it will not make any submissions in relation thereto and will wait the final report. On the 3rd of October 2024, the Office of the Speaker referred the final report to the committee for its consideration. In summary, the Public Protector in her report found, among others, that there was merit to the allegation that there was undue delay by the functionaries of the Department of Correctional Services to act in compliance with the regulatory prescripts and procedural requirements on information received regarding the escape of Mr. Bester from Mangaung Correctional Centre. Pursuant to the above findings and in accordance with Section 182(1)(c) of the Constitution, which provides that the Public Protector has the power as regulated by national legislation to take appropriate remedial action. The Public Protector took the following remedial action. The Minister of Correctional Services must take note of the findings of improper conduct against the DCS functionaries as highlighted in the report, in connection with the allegation that there was undue delay by implicated officials of DCS. The National Commission of the Department of Correctional Services must, within 90 calendar days from the date of receipt of the report, develop an appropriate DCS escape prevention strategy and guidelines for the Mangaung Correctional Centre facility, indicating monitoring mechanism, proper systems to be put in place, directing how the functionaries of the DCS and contractors must effectively prevent and manage escapes of inmates within Mangaung Correctional Centre, including all other correctional facilities. Number 3, the commissioner must, within 120 days from the date of receipt of the report, ensure that the DCS has a documented guideline which communicates how anonymous anti-corruption reports from the centralized office of the Public Service Commission's hotline and other sources will be attended to by DCS, in line with the purpose and the object of the Protected Disclosures Act of 2000 and other relevant prescripts. The report further noted that since the DCS has already taken disciplinary actions against its implicated functionaries, therefore the public protector will not be taking any further remedial action in this regard. And lastly, in relation to the Speaker, the public protector directed that the Speaker must, within 30 days of receipt of the report, bring to the attention of the chairperson of the committee to take cognizance thereof, in line with the powers contemplated in Section 55, subsection 2 of the Constitution. Thus, the legal question to be considered in this opinion is as follows. In light of the litigation related to a contractual dispute between the Department of Correctional Services and G4S, does the National Assembly Rule 89 of the National Assembly Rules prohibit the committee from exercising its obligation to act on the report as directed by the public protector in her remedial action? For a bit of a legislative framework, Section 42, subsection 3 of the Constitution provides that the National Assembly is elected to represent the people and to ensure government by the people under the Constitution. It does this by choosing the president, by providing a national forum for public consideration of issues, by passing legislation, and by scrutinizing and overseeing executive action. Section 55, subsection 2 of the Constitution requires the National Assembly to provide mechanism to ensure that all executive organs of state in the national sphere of government are accountable to it and exercises oversight of national executive and any organs of state. NA Rule number 89 under the heading Matters Sub Judice provides that no member may reflect upon the merits of any matter on which a judicial decision in a court of law is pending. Sub judice is a Latin phrase meaning under judicial consideration. It denotes that a matter is being considered by a court or judge and restricts public comment, which may be prejudicial to proper administration of justice in respect of such matter that is still pending before court. The sub judice rule has its origins in the jury system and intended to ward off the influence of public comments on members of the jury while the matter is still pending before the court. The violation of sub judice rule can be regarded as a criminal offense, that is the contempt of court. In the context of the National Assembly, NA Rule number 89 amounts to a prohibition against any member from making reference to any matter before courts. This rule is intended to promote respect of the judiciary and its processes and the adherence to this doctrine of separation of powers. It is an established principle of our law that all rules and legislations must be interpreted with due regard to the Constitution. In another court case in Medi Television versus Director of Public Prosecution in the Western Cape, the Supreme Court of Appeal clarified the application of this common law principle and altered our jurisprudential landscape regarding the interpretation of the sub judice rule. Just for a bit of background, in this case, a 6-month-old baby was brutally murdered in Cape Town, and immediately this captured the attention of the public. And this horrific crime received extensive media coverage. The appellant, a television broadcaster that broadcast under the name ETV, made a documentary on the matter and sought to broadcast it. The Director of Public Prosecutions for the Western Cape brought an urgent application in the Western Cape High Court for an order prohibiting the broadcasting of the documentary, and was granted the relief. The appellant then took the matter on appeal to the Supreme Court of Appeal, and the decision of the Western Cape was overturned. In this regard, in the need for the balance between the freedom of expression and the administration of justice, Nugget J.A., that is the judge that was dealing with this matter, stated that publication will be unlawful and thus susceptible to being prohibited only if the prejudice that the publication might cause to the administration of justice is demonstrable and substantial, and there is a real risk that the prejudice will occur if publication takes place. A mere conjecture or speculation that a prejudice might occur will not be enough. Even the publication will not be unlawful unless a court is satisfied that the disadvantage of curtailing the free flow of information outweighs its advantage. In this case, the court pointed out that a mere speculation of prejudice that may occur to the administration of justice in relation to the matters before court is not enough to prejudice the administration of justice. The court's restrictive interpretation of the sub judice rule means that it will only apply in limited instances where it is demonstrable that there is a real risk that substantial prejudice to the administration of justice will occur. Even if this criterion is met, the publication of information may only be restricted if a court is satisfied that the disadvantage of limiting such publication outweighs its advantage. This is a very stringent standard that must be satisfied before a limitation is placed on a publication related to matters pending before court. In another matter, in the Public Protector versus Speaker of the National Assembly and others, NA Rule 89, which provides for the sub judice principle in the National Assembly, came under judicial scrutiny. In this matter, the applicant sought an order, among others, declaring the conduct of the Section 194 Committee in proceeding with Section 194 inquiry irrational, unconstitutional, and invalid. Applicant submitted that Section 194 Committee's decision to press ahead with the inquiry breached Rule 89 of the National Assembly rules. The High Court held that the National Assembly's obligation to hold her accountable would have been stultified if the sub judice rule was applicable. In Democratic Alliance and another versus Public Protector of South Africa and others, the Constitutional Court confirmed the decision of the Western Cape High Court in the Public Protector matter and held that the sub judice rule does not preclude members of the National Assembly from carrying out their oversight functions and holding the Chapter 9 institutions accountable. NA Rule 89 is a limitation that Parliament imposes on itself and is a rule for debate. The reason for this rule is that in terms of the doctrine of separation of powers, Parliament respects the independence and the authority of courts to decide matters before it. Parliament also respects the constitutional right of litigants and accused persons to have their matters fairly adjudicated in an independent and impartial manner. The restriction placed on members in terms of Rule 89 is very specific. Firstly, there must be a pending case that is awaiting to be adjudicated in a court. Secondly, where a matter under discussion relates to a pending court case, a member is only restricted from commenting on the merits of the matter. In other words, within our constitutional framework, any Rule 89 must be interpreted narrowly and not as a complete bar to the National Assembly from processing a matter legitimately before it. In this case, the overarching constitutional mandate of the committee is to ensure accountability and exercise oversight functions over the Department of Correctional Services. The subject care rule does not operate as a prohibition on the committee fulfilling its constitutional mandate, including that of oversight. The committee will be considering the findings and remedial actions of the Public Protector's report. The committee will not be considering the merits of pending litigation matter between the DCS and G4S. If in the event that an issue related to G4S contract arises before the committee, members may discuss the issue without commenting on the merits of the pending litigation. In relation to remedial action of the Public Protector, it is tried that a remedial action taken by the Public Protector has a binding effect and enforceable. In the Constitutional Court confirmed that in the matter of economic freedom fighters versus the Speaker of the National Assembly and others, Democratic Alliance versus Speaker of the National Assembly, where the Public Protector have taken the remedial action in terms of Section 182 of the Constitution. The court confirmed that it is binding unless it is set aside by a court order or subsequent review. Mogoeng CJ made the following remarks to emphasize the importance of the remedial actions of the Public Protector. I quote, "If compliance with remedial action taken were optional, then very few culprits, if any at all, will allow to have any effect. And if it were by design never to have a binding effect, then it is incomprehensible just how the Public Protector could ever be effective in what she does and be able to contribute to the strengthening of our constitutional democracy." Close quote. In light of the above, the committee may not ignore the remedial action taken by the Public Protector in this matter. The overarching constitutional mandate of the committee is to ensure accountability and exercise of oversight functions. In this instance, the committee is, in terms of Section 55, subsection 2 of the Constitution, required to exercise oversight on the Department of Correctional Services in relation to the implementation of the remedial action taken by the Public Protector and ensure that such remedial action is fully complied with. The Public Protector did not dictate to the committee on how it should go about in processing the remedial action. In the economic freedom fighters case that is cited above, the Constitutional Court held that the mechanics of how to go about fulfilling these constitutional obligations, that is oversight role of the executive and other organs of state, is a discretionary matter best left to the National Assembly. In conclusion, in view of the above facts and the applicable case law, it is my considered view that Rule number 89 of the NA rules, read with the constitutional provision referred to above, does not preclude members of Parliament from complying with the remedial action taken by the public protector. Any rule has very limited application in that the members may not reflect on the merits of the pending litigation. Therefore, I am of the view that in this context, the committee has the constitutional duty of overseeing and monitoring the implementation by the DCS of the remedial action taken by the public protector. The remedial action taken by the protector is binding and therefore must be complied with. We so advise. Thank you very much, Chairperson.
Thank you so much, Mr. Simani, for the presentation and taking members through, or the portfolio committee through, on what the Legal Service of Parliament advises the committee on the PP report. Members, do you have any clarities, questions to Mr. Simani before we can do our own deliberations and submissions to the PP report? Honorable Engelbrecht.
Thank you, Madam Chair. I just have a few questions. The date of the report, I have it as the 30th of September. Is this correct? Because it has a bearing on the target dates stated in the recommended remedial actions. And I see that the report ends, which I can only describe as a stern warning not to be in contempt of the public protector. And then, yeah, let me leave it at that, because I think we'll get into the content of the report at a later stage. Thank you, Madam Chair.
Mr. Simani, Sia, you will come in as well. When did we receive the public protector's report from the Speaker's office officially?
Thank you, Chairperson. As we can recall, the report we received, in fact, for our office, we received it on the 3rd of October.
Okay, from the legal, it's 3rd. Okay, Sia will work on when did we officially receive it from the Speaker's office, because the report was circulating before we as the portfolio committee or my office can receive it officially from the Speaker's office. It was already doing rounds. Sia, are you able to come in?
Yes, Chair. I'm trying to open the letter, Chair, so I can get the actual date from the letter. But my PC seems to be jamming. Just a few seconds, Chair. My apologies.
From my side, okay, I think indicate final report, Speaker. Okay, we also got it on the 3rd, Sia, the 3rd of October. I'm looking at the letter officially from the Speaker's office addressed to me, and it indicates the 3rd of October. So the Speaker sent it out on the 3rd of October. Are you able to confirm, Sia?
Yes, Chair. Yes, Chair. We received
it is the 3rd.
Yes, Chair.
Okay. It's the 3rd of October, Honorable Engelbrecht, and it's the 3rd of October that was also sent to the Legal Service Department for a legal opinion. Do you have a follow-up on it?
Madam Chair, I just want to confirm also that because it also has an effect on the Department of Correctional Services, because it's stated in the recommended remedial action that 30 days and 60 days and 90 days and whatever from the date of receipt. So we need to also determine from the Department of Correctional Services when did they receive it, because I know the Public Protector published her report on the Public Protector website on the 30th of September. But now that is not to say that, you know, she officially handed it over to whoever. I mean, as we saw now, the speaker got it on the 3rd. And so we also need to determine from DCS, because then the 30 calendar days, you know, if it was the 30th of September, then the National Commissioner would have to comply with the first date is tomorrow. If it was the 30th. Obviously, if it's the 3rd, the date moves a bit on. We just need to determine that.
We'll get that when we meet with the department, whether they've complied with the 30 days rule and all those days that are mentioned. There's a 90-day, there's 120 days, there's a 30 days as well, whether they have complied with them. So ours was to get the Public Protector's report and act on where the portfolio committee needs to come in. And it was published on the 30th in the Public Protector's website, but it was duly sent to us as the portfolio committee on the 3rd of October. So we can't speak on the other days. That's when we officially found it. But I can confirm that I also interacted with the report when I've seen it circulating before the 3rd of October. And there was nothing we can do about it until we get it formally from the Speaker's office, because that's how our line function operates in Parliament. Members, since we do not have clarities and questions to Mr. Simani, deliberations on the matter, on our role as the portfolio committee that we need to play with regards to remedial actions to the Public Protector's report, as advised by the legal service. What's your take on it, and how can we best approach this? Honorable Engel. Engelbrecht, is it?
Yeah, I almost struggled to unmute you. Sorry.
Okay.
Madam Chair, I think in terms of this report, it's fine that there's not many things that we need to have a look at. However, I need to, you would remember that the 6th Parliament Portfolio Committee embarked upon this matter, and that process has not been concluded. And I think it's not only just, but I only think there's a legitimate public expectation that the parliamentary process that we started in the previous term be concluded. I think it should be, it would be in our advantage, to our advantage, if we can have that, start that process again in conjunction, obviously, with the current Committee of Justice that also formed part of that initial process. And we can then look at all the outstanding matters, as well as these few things that the Public Protector recommends.
Okay, thank you, Honorable Engel. Honorable Muela.
Yeah, thanks, Chair. I'm not so sure if I'm allowed to speak with my video on off in this regard.
We can see whether we can see is it you, Honorable Muela, then you can unmute. It's entirely up to you.
Yeah, greetings, Chair.
Okay.
As you can see, it's me. Yeah, I will firstly like to welcome the legal opinion on the Public Protector report and its remedial actions. I think important to note, Chair, is that the importance of the remedial action has been highly emphasized in this report. So we have seen the occurrence of precedents in this instance with regards to many issues which happened before with regard to the remedial action of the public protector. We cannot overemphasize that particular issue because we understood very well that it was clear that it's binding. So I think in terms of our responsibility as a portfolio committee on playing oversight on DCS, for us is to ensure that we play oversight on the DCS to make sure that they implement the remedial action on the time frame that it is stipulated on the public protector report. I think we have to then look into what with the work that has been done with regard to the sixth administration on the particular matter at hand. The legal opinion has been very clear in terms of interfering maybe on the matter between the DCS and the G4 services, that it will not have any impact on our work as the portfolio committee. It's stipulated by certain statutes which govern the particular operations of the committee. So I think in this instance, Chair, as a portfolio committee, we need to make sure that we play our role in ensuring that remedial action are implemented, because there are legal consequences if we fail to then play that particular oversight, and also to ensure that the department do due diligence with regard to this particular matter. So I think we need to then have a determination and a way forward as to which approach will be best in making sure that this matter it is well taken off and it is closed in a proper way, that it will give a proper direction as per the remedial action. I think the remedial action are very clear as to what role should the National Commissioner play in this instance, what role should political bearers have to play in this particular role. So ours is to make sure that we then give guidance to that particular process. So that will be my submission, Chair. Thank you very much.
Thank you, Honorable Moila. Is there no hand? Honorable Engelbrecht, is that a legacy hand?
No, it's just it's one for clarity. I just want to mention that obviously we have to see to it that the recommendations of the public protector's recommendations are adhered to. However, the scope of this public protector investigation was rather narrow. If you go to the right at the beginning, it was from a member of the public that made the submission to the public protector. Now so the scope is not very wide. There's lots of things, and I don't think that as a portfolio committee we should only exclusively look at DCS and others complying with this specific narrow little piece that the public protector addressed, because obviously this matter is very wide. There's lots of things that we need to apply our minds to. As I said, in the previous administration which we did not conclude. There's lots of things, and I do understand that there's an ongoing court case between MCC and Correctional Department of Correctional Services, but however, that does not preclude us from pursuing the matter, notwithstanding, you know, the litigation that's going on. But there's a lot of things outstanding, and we need to come to a conclusion on that matter, those matters. Thank you.
Chair,
Who's saying chair?
my apologies for having challenges.
Okay,
My
Honorable
hand-
Sokopa.
I can't raise my hand. You see, Chair, and I like the second submission of Honorable Engelbrecht, because it confirms what has been running in my head, that yourself and Honorable Engelbrecht, you are going to abuse us in this committee by continuously make reference to the sixth administration like he has just done now, to an extent that he criticizes the report of the public protector that is before us, that we must deal with, and rather reduce it to being narrow and say that there are other issues that they would have attended. This thing is broader than what. My suggestion to this committee is that let's focus on what we have before us now and give advice or agree on an approach on how to deal with what we have now. I think Honorable Moela have touched on a couple of issues that part of, and I think Honorable Engelbert have also touched on it when the two of you and Sia were double checking whether are we within the dates, within the 30 days, if there's 30 days, and 90 days, if there's 90 days. And you have made a good submission, Chair, when you says that let's rather double check ourselves with Correctional Service whether within the 30 days given, is there any movement from their side on what the public protector have raised as remedial action? That's what we would have to do. The appetite of getting to another space, I'm sure it will be only fair to all of us in this committee to appraise ourselves with that the two of you probably would know and deal with it at some other point if there would be a need for such. For now, my suggestion is that let's focus on what we have. Let's see to it that we see that the DCS that we have an oversight role with is complying with the remedial action of the public protector. I don't think we must have go to where Honorable Engelbrecht even wants to reduce this report that is so important that he spoke about, that is everywhere in South Africa, to being narrow. I think that's what was placed before the PP, and this is what the PP have given us as a committee to deal with. And let's just focus on the report and see to it that there is compliance as per the remedial action. Thank you, Chair.
Thank you, Honorable Sokopo. Honorable Moela, is it the legacy hands or the new hand?
Thanks, Chair. I just want to add one important matter which I think I did not overemphasize on with regard to cautioning us to say, I think the litigation process that is in between the DCS and the GF services is already crippling the finances that we don't have in the department. So I think whatever determination that we should draw as a portfolio committee should not then fall into a point where we'll have to want to overspend taxpayers' money, which we don't have in the country, and also with regard to the department. I think the remedial action, Chair, are very clear as to what must happen. I think in terms of the guidance, we need to then make sure that we play overall an oversight on this particular matter, other than just trying to want to go beyond imaginations, which will then cause serious problems which we already have. We need to to focus on ensuring that we close the matter in a point where we don't even cause too much expenses to such a particular extent, to a point where we might even think of broadening and bringing things of commissions and other things which will drag and cause us too much money which we don't have. I think we just have to comply with the remedial action other than just trying to spread and bring other issues which I think will then create more problems going forward. I think that is the last point that I think I needed to overemphasize on, Chair. Thank you very much.
Thank you, Honorable Mwela. Mrs. Ngaba.
Thank you, Chair. I just want to respectfully disagree with my colleagues Sokopo and Mwela. So the problem is you and Engelbrecht will be able to attest to how much time and effort went into you guys following this issue in the previous administration. Now, Honorable Engelbrecht did not say in any way that this report is useless or not enough or whatever, but I think the point he's making, in defense of the public protector, she can only deal with what is put in front of her. And what was put in front of her was narrow. So to be fair, I think we're all on the same page. We need to follow through on this report and make sure that it is adhered to. But my suggestion would be, can we get researchers or somebody to just review what you guys did last term, pick up on the important points that have not been followed through, and add that to our oversight. We are already overseeing this issue, and it's wasteful to say the 6th administration did so much work, we're just going to leave it in the trash bin and start again. We need to follow up on all the important stuff that you did and the important stuff that the public protector has done, and make sure that we deal with this issue fully. We don't want to leave strands unattended to. So I do think it's important. We don't have to pick up everything. We don't have to relitigate everything that happened in the 6th administration, but any important strands that were left unfollowed and are not dealt with in the public protector's report, we need to look at those, because ultimately our goal is to make sure that something like this doesn't happen again, and to make sure that those involved are held accountable. And we can't do that if we are looking only at smaller pieces here and there. We need to look at the full picture and address everything that happened fully and comprehensively.
Thank you, Mrs. Ngaba. Honorable Mwela, is that a legacy hand?
Yeah, I think it's a legacy hand, Chair. Sorry.
You can take it down. Thank you. Colleagues, in the 6th administration, on how we dealt with the Mangaung or the Thabo Bester escape, it was through an inquiry which was for 2 days. And in that inquiry, we couldn't even finish because there was so much to absorb. There was too many information, and equally, we had brought, I think, 3 departments. At one, it was Justice and Correctional, it was SAPS, it was also G4S, which is the company that is managing the Mangaung Correctional Facility, or the PPP. So we had to have Mangaung, we had to have DCS being summoned by Parliament, because when we had them to appear before the portfolio committee, there was resistance. They wanted to be summoned, and initially we did summon them to come in 2 days of work that the inquiry would have done, but still a lot of things were not clear. I remember there are reports that are equally outstanding from that inquiry that we needed to get. Mathabate, did we manage to get all the information that was outstanding from Integriton, which it's the company that is managing the IT system, which is your videos, cameras, and all that thing. The backup, that seems to be non-existent. And then you would have also outstanding information or reports from the G4S. Sia Mathabata, did we manage to get all those outstanding documents that that inquiry would have asked for? If we did.
From my side, I can't recall at this stage, Chair, but I think together with Sia, we'll check also with Bonani. Thanks.
Oh yes, Bonani was the one dealing with it. Please kindly do check. Unfortunately, Ms. Ngaba, we do not have a research in the portfolio committee. Mr. Mathabata is a content advisor, but plays a role also for research, assisting in the research position, because we do not have, and it's on a basis that we are now a new committee. So when we were clustered with justice in the 6th administration, we had researchers. But now that we're a new committee, research has remained in the Justice Committee, and we do not have that. So we'd equally solicit assistance together with Mr. Mathabate to assist as well with the research unit of Parliament to come in and assist and back us up in trying to review and research the whole inquiry on outstanding information that we require and also on areas that the portfolio committee of the 7th administration can look into, so that we do not have a final inquiry that still touches on what we've touched on previously. It makes no point, and it does not even do much of an oversight role that we do. And look also on matters that are before the court or are under litigation, because we did have an issue with SAPS when it needed to give more information regarding the issue of the bodies that were being collected, the issue of the case and so forth, and they would respond to say the matter is sub judice, so they could not divulge more in the inquiry because of the matter it's before court, and that's where merits and everything would be divulged in. So that team or that component of the researchers must equally look at those matters that are before court that are sub judice, that the portfolio committee will not be able to look into, because the G4S contract and the department is still before court. It's under litigation, so there's not much that we can speak on those. The Thabo Bester escape on its own. The Thabo Bester escape on its own, it's still a matter before court, with all those who were employed by G4S or who are suspected to have equally planned that escape are also appearing before court. So on its own as well, it places the portfolio committee in a dicey situation. But I do agree that this team of researchers should look into the matter and be able to put together what is it that the portfolio committee can look into if it decide to finalize this matter in the future, so that we do not do what we did previously, which did not even do justice entirely to that inquiry. That's one. Two, the remedial action of the public protector says the 90 days, they've given the National Commissioner 90 days to submit a report. And this is based on receipt of the report. So if it goes to the 30th of September, it means 90 days. So it will end in December. They've given the commissioner 90 days to develop an escape prevention, safety, and guidelines for Mangaung facility, indicating monitoring mechanism, proper systems to be put in place, directing how the functionaries of DCS and contractors must efficiently prevent and manage escapes of inmates in that facility. So we need to make sure that as the portfolio committee, DCS does comply with that remedial action as put by PP. Again, the PP says the commissioner within 120 days from the date of receipt of the report must ensure that it has documented guidelines which communicates how anonymous anti-corruption reports from the centralized office of the Public Service Commission's hotline and other sources will be attended to by DCS in line with the purpose and the objectives of a Protective Disclosures Act 2000 and other relevant prescripts. And then where it spoke about DCS taking those who were in the controller in Mangaung for disciplinary action against them. It further says it will not do any, it does not recommend any further remedial action because already there's consequence management on the matter. So the portfolio committee needs to make sure that the department complies with all the stated remedial action from the PP, the escape prevention strategy, and also the anonymous anti-corruption report or strategy that the department will have to do and submit this to the public protector. But before they could submit to the public protector, they must come before the portfolio committee and take the portfolio committee through all these two remedial actions. And then we equally as the portfolio committee engage on it and make submission so that they are in compliant with what the public protector would have requested them to do. So ours is to hold them accountable as the portfolio committee by playing our oversight role and make sure that they do comply to all remedial action. There's where they wrote, they spoke of 30 days of the commissioner. I'm trying to look for it. Mrs. Ngaba, is it a legacy hand?
No, Chair.
Yes.
No, I was just going to say, so thank you. I heard what I understood from what you said. You are going to ask the research team to help collate the stuff from that inquiry so that we don't sort of redo things that have been done. And I also understood that the team is going to follow up on any outstanding reports. The one request I was going to make, if there are any existing documents from that inquiry, not outstanding ones, that the team is able to share with the new members so that we are on the same footing in terms of knowledge of what was submitted, what was seen. It would be really helpful if we could all receive those documents. Thank you.
Thank you, Mrs. Ngaba. Sian, Mr. Mathabate will do as wise, but the research team should also be able to pick up everything that was submitted before the 6th Parliament, including all documents that were submitted on the inquiry, so that we don't redo the inquiry because it makes no point. It happened already. We need to follow up on those that the commitments that were made in the inquiry, whether they have been followed through and have been done, and the recommendation that the portfolio committees, which was Justice and Correctional, would have made to that inquiry, so that we don't repeat the very same things that have been done. There is a last part of 30 days calendar of that the DCS must submit an action plan to the public protector within 30 days. And I think that is the 30 days, Honorable Engelbrecht, you were referring to on the date of receipt of the report, which would end is it it's not tomorrow. Today is the 28th, 29, on the 30th. So we should also, when we call the department before, then it should be able to take us through whether they have made that submission of an action plan to the public protector. Because it starts there, it's 30 days, it's 90 days, and then it's 120 days to comply to all remedial action that the public protector would have flagged for the portfolio committee to do its oversight role over the national executive, including the department. So that's how we wrap up the meeting, colleagues, that we will then have a meeting with the department, the executive, the department, to take the portfolio committee through on all remedial action that the public protector has flagged, and for them to comply with. And are they compliant? And the first point will be the 30 days if they would have made a submission of that action plan, and following the 90 days escape prevention strategy, including the 120 days one, and take the portfolio committee through with those reports. The action plan, we might be late for them to present to the portfolio committee, but they must be able to bring it, the 90 days and the 120 days, to equally take the portfolio committee through before submissions, and then be compliant, be able to submit to the public protector. Matabat, Sia, let's then have a discussion with the research unit on the scope of work they need to assist the portfolio committee on, since we do not have a researcher. And we have been using you, Mr. Matabat, as a researcher, whilst you are not, you are a content advisor. But let's solicit assistance from the research unit to be able to deal with this matter. And also liaise with Mr. Ramano, who was the committee secretary when we did the inquiry. So all the minutes and everything were done by him, so that he does give us the information of that inquiry. And let me correct something. We summoned G4S, not TCS. TCS would have came to the inquiry, the first one that did not sit, and G4S did not, which is the company that it's contracted or overseeing the PPP in Mangaung. Immediately after that, we had to summon G4S for them to appear before the portfolio committee or the inquiry to answer questions and clarities that portfolio committee members would have in that regard. So we wrap up the legal opinion in that sense. And let's also thank Mr. Simani for availing your time, and also to be able to guide the committee on its role on the PP, and also for availing yourself today to take us through your advices or your recommendation as the legal service. Thank you so much, Mr. Simani.
Thank you, Chairperson.
You are therefore released from the meeting.
Thank you, Chairperson. Thank you.
Sia, kindly flag the other item of the agenda. It's minutes. I know we're going to minutes. Babu Kasa, are you still here?
Yes, Chair, I am.
Ngiyabonga.
Yeah.
Uhlala ku virtual meeting anginiboni. Okay, draft minutes. I'm touching my screen. Members, part of the agenda item, it's for us to deal with minutes. And I think we have all received the minutes and they are read. So we'll take them as read because of you would have received the minutes last week. Is it last week, Sia? When did you send to members? On Friday? Yes, so we take the minutes as read. Now can we start with page 1 if there is where we need to fix, if it's not captured correctly. Page 2. Page 3. Page 4. And then page 5. Are this a true reflection of what happened, members, on the 17th of September, when we had the National Council of Correctional Services, NCCS, before the Portfolio Committee to take us through its own structure on how they functioned and also the current workload that NCCS had, or their consideration process that they do once they receive profiles? Members? Honorable Moela?
Yeah, I move to indicate that it's a true reflection of what transpired, Chair.
Any seconder to the report or the minutes?
Seconded, Chair.
Ms. James, seconds. So these are the true reflection of what happened on the 17th. Sia, let's move to another minutes. Briefing by GICS on its annual report, which was on the 15th of October. The minutes would be taken as read, received and read, because I would have received them on Friday. Page 1. Everyone was present. Page 2. Page 3. And page 4, which is the last page. Do we take this as a true reflection of what happened on the 15th when we had GICS before us presenting its annual report?
Chairperson.
Honorable Kluete?
Chairperson, I can confirm this is a thorough reflection, so I move for that.
I couldn't hear you properly.
I said, Chair, I can confirm It's a true reflection. So I move for the adoption of this minutes.
Okay, thank you. Do we have a seconder?
I second, Chair.
Mrs. Ngaba, seconds. And then the last minutes here is briefing by DCS on its equity plan and vacancies and disciplinary matters and suspicions that they have in the department. And we also included an update by the minister on the backlog of lifers or parole process. The minutes will be taken as read since we have received them on Friday. Page 1. We only had an apology of Honorable Muela. Everyone was present. Page 2. Page 3. Page 4. Page 5. So yeah, let's fix the grammatical spelling on Luokop. It must be L-W-E-U-W-K-O-P, Luokop. And then page 6. Is this the true reflection of what transpired on the 22nd of October, which was last week, when we met physically in committee room 1? Members? Members, the draft minutes, do we adopt them? Or we're saying they're not a true reflection of what happened?
Chair, I move that we adopt them.
Mrs. Ngaba, seconder.
Honorable Pluto, second.
Honorable Clute, seconds. Thank you so much, Honorable Clute. Honorable members, for adopting all the minutes of the previous portfolio committee meetings. So we do not have any outstanding minutes in terms of our work. The only outstanding report we have is on the oversight, which it will be presented very soon, next month, for the committee to interact with and then formally adopt the report, so that then it can be taken to the House for declarations to be made. The final one would be the program, the third term program. As you would have, as I indicated previously, that there is changes to the program, or as and when we move, there would be changes on the program, basing what the chair of chairs, Honorable Frolik, will send to the committees, all committees of Parliament. So there is a correspondence or a letter that you would have seen, members, that has been circulating, that makes an indication that next week, which is the 5th up until the 8th of November, it's now constituency week. So it means we must then amend our third term program to include the 5th until the 8th as a constituency week. Therefore, everyone will be in their constituencies doing their constituency work, and therefore will not be able to do any portfolio committee meetings. And then there is another correspondence also that says from the 18th, if I'm correct, Sia, until the 22nd. Yes, until the 22nd, which is Monday until Friday, it becomes a committee week. So in that committee week, what happens is that there will be no National Assembly. We are then, as the portfolio committee, allowed, or portfolio committees in Parliament allowed to sit the whole day and deal with any outstanding committee work. We can even make a determination to meet on Tuesday, meet on Wednesday again, meet on Friday, if there is a lot of work that is outstanding from the portfolio committee. So in our case, we do not have much of outstanding work, but you remember, we were supposed to, in the BRRR week, we were supposed to meet to have the department appear before the portfolio committee in presenting the annual report, and equally meet with the Auditor General on findings on the annual report of the department. So since we couldn't meet them in that BRRR week, because of their still pending matters between the AG and the department that they needed to finalize, that they were not finding a common ground on, they seem to have now found each other, and they've agreed on their reports, inclusive of National Treasury as well in that aspect. And therefore, we would need to schedule the department to present the annual report. Hence, I bring the program matter before you members, so that these changes and amendments that are happening, we are all aware of them, so that we're not caught off guard, that you don't know next week what's happening and so forth. This would have been the third program that we have adopted before we went to recess. So on the today, which is the 29th, we're meeting the legal services. We've done that part. As indicated, the 5th until the 8th is constituency week, so meaning next week, there is no portfolio committee meeting. Then when we come back on the week of the 11th until the 15th, we are meeting on the 12th. We'll get a briefing by the department on infrastructure projects that they have. All infrastructural projects that they have, all outstanding ones that are not yet completed. What is the timeframes, when is the anticipation to complete all those infrastructure projects. And then the week of the 18th until the 22nd, I've made an indication again when I started to say it's dedicated to committee week. Therefore, on the 19th, which is Tuesday of November, we'll then have an overview of the department on its annual report of 2023-2024. Then we'll also meet with the AG to take us through the findings of the annual report of DCS. So it will be the whole day Tuesday, and it will be a physical meeting where we'd get the Auditor General and then the department to present. Initially, when we amended the report, since we didn't know when the annual report will be presented or when would AG and the department find one another, we had put, we equally need to, after the meeting, have a briefing by DCS if there is an action plan that they must do based on the finding of the AG, so that they take us through as a department, including the litigation process that the department might be going through. And we know it's in relation to IMS. So we're thinking of having this meeting also during that week of the 18 to 22, but that is subject to availabilities, members. So Sia will check your availabilities. We know that you belong to other portfolio committees outside Correctional. I know Ms. James, Honorable Muela, Truett, and Sopopo belong to police as well, which sits on Wednesday. So I'm not sure other members belong to which committees. Engelbrecht belongs to Justice as well. We're not sure Mrs. Ngaba, Honorable Jonas, Babgasa, and Honorable Mwali, and Mrs. Diali, which portfolio committees they belong to outside Correctional, so that then we look at a suitable day between Wednesday, Thursday, and Friday that we can meet to then speak on the audit action plan of the department that would have been flagged by the AG, including the litigation process that the department has with regards to a contract on the IMS program. So this will be on the basis of your availability on that week of the committee week. The 26th of November, it still stays like that, it's not changed. Update by DCS on the state of readiness to take over Triple P's facilities, which would be Kutamas in Tumule, in Toyando, and Mangaung Correctional Facility in the Free State. And also update the portfolio committee on the litigation that is currently underway with G4S, which is Mangaung facility, on the issues of the department took a decision to terminate the contract of TCS after the Thabo Bester matter. Then on that day, we equally would want to adopt minutes of the portfolio committee, the oversight report that would have done in Gauteng, and also prepare, take the portfolio committee in preparation of the coming oversight report, which was supposed to have on the first week of December. But however, what we got from the chair of chairs is that the first week is no longer highlighted as oversight week, it's now highlighted as committees. So I've agreed, I took a decision that I will engage Honorable Frolic and solicit a view that are we still allowed to have an oversight even though it's a committee week. Then upon his response, we'll come back to the portfolio committee what would happen on the first week of December, if we still are proceeding with an oversight or it will be committee week. But Parliament normally on the last week of December, or the last week, the first week of December, that is the week that we equally go to recess, constituency week, and then recess. It gets congested with the scope of work, of reports that needs to be adopted, and all outstanding things that were supposed to have been done. But I will come back to the portfolio committee on that. But if then we're given a leeway to have an oversight as the committee, we will then finalize the preparation of oversight on the 26th of November. On the 3rd of December, which would be our last portfolio committee meeting, it's supposed to be our last portfolio committee. In terms of programming, they have listed plenary, which starts at 10. I indicated that normally that first week of December, which is the last week of Parliament, of National Assembly, they congest a lot of work. So normally plenary starts at as early as 10 o'clock in the morning. So already programming is listed that on Tuesday, the 3rd of December, plenary starts at 10. Therefore, it means we will not have a portfolio committee meeting, because we can't have a portfolio committee meeting that clashes with National Assembly unless we apply to sit, if we have an urgent matter to process as the portfolio committee. So members, this is amended, proposed amended third term program for yourself, which you already have, but we needed now to slot in the annual report of the department, including the audit action plan that will arise from the findings of the AG, and just play around in accommodating the constituency week, which is next week, including the committee week that we are given. So it's up to you, it's over to you members, whether you are okay with the report as it is, or there is something that you want to flag or for us to rework on. Members, I take it we're fine with the amended third term program.
Yes, Chair.
Okay, then SIA will send an updated one as read now, to be the final third term. Let me not say final. There might be changes as well, because it seems to be, we seem to be having more changes in the portfolio committee. So there might be changes. SIA will then send an updated one. Mr. Matabat, have we started on the research work of a study tour for the committee to take on the, I think the scope of work was the bail application and what as well?
It was on bail application, as well as, remember, we were anticipating a legislation from JICS. So we also had that in mind to look at other jurisdictions on how they deal with the judicial inspectorate in terms of the prison visit.
Okay.
But I think, Chair, we will also look at what we were proposing in the last administration for that study tour and align it with our what this committee wants to achieve. Thanks.
What was the last time? Do you still remember those?
Not on top of my head, but I think we've got the document.
Okay. Please work on it, and then let's share, so that then we can share the scope of ideal study tours that the portfolio committee must do. Study tours seem to be opened. I'll have an engagement with the chair of chairs, and if they are opened, we must be able to send an application of the portfolio committee to do a study tour, so that even on the legislation of JICS, before they could start with it, at least would have benchmarked in other countries on how they function with the judicial inspectorate, so that when JICS comes in, we are equally ready. And if what would have benchmarked on sits well with us, and we are recommending that it should happen in our country, then it would be in the best interest that we are able to approach it in that way, members, and give proper inputs that are informed as well, outside the research work, but also in practicality on how other countries operate as well. So yeah, I wanted you to start working on that, Mr. Matabata, so that we are not found when that process opens, because it's opened now. When that process opens again, we are wanting to start to find ourselves whether which country are we benchmarking, on what is it that we're benchmarking. So let's bring those suggestions to the portfolio committee, and we put them by order of priority in terms of benchmarking, and then we start the application for the portfolio committee to do a study tour. So members, since next week it's constituency week, will not be meeting as the portfolio committee, and wish you well, safe on your constituency week in your deployed areas. And today's meeting was to get a legal opinion from the legal service, which we got on the remedial actions the PP has put to the department, and ours would be to play our oversight role and to make sure that the department is compliant with those remedial action. In actual fact, they do implement and do as indicated by the public protector. Ours is to make sure that we monitor that process and make sure that they do account on those remedial action, which is the 30 days one, the 90 days, and the 120 days as indicated by the PP. So members, the meeting, thank you so much for coming through and availing your time. The meeting stands adjourned. We'll see each other in the house.
Thank you, Chair.
Thank you.
Recording stopped.
Yeah, can end the meeting.